Hello, everyone. I'm Alaka Oswald, Senior Vice President of American Friends of ABH. I wanted to welcome you to our Humboldt Dialogue today. Thanks so much for joining us. These Humboldt Dialogues are made possible in part by support from our generous donors. Thank you. This event came about after the relaunch of our Humboldt Network Liaisons program last year. HNLs help spread the word about AVH programs at their institutions, host gatherings of alumni in the region, or share their expertise with the rest of the Humboldt network through events or written contributions. Humboldtian Jud Mathews, Professor of Law at Dickinson Law at the Pennsylvania State University, spent 2021-22 at Berlin's Humboldt University, so a double Humboldtian. He joined us as a Humboldt Network liaison last year and approached me about organizing an event on the German Constitutional Court. He brought the distinguished panel of speakers to us, and we are providing the platform. This is a great example of the cooperation that is possible, and I encourage alumni to share your ideas with our office. Without further ado, I will now turn things over to Judd to introduce our speakers and begin the event. Thank you.
Thank you so much, Yanka, and thank you everyone for being here. Thanks also to my colleague Carrie Jackson, who's provided a room for me here in the German department at Penn State. This event came about in large part because I was interested in learning more about developments involving Germany's Federal Constitutional Court in the last year or so, and thought I would turn to some trusted friends and colleagues to shed light on recent events. And it occurred to me there might be others as well who would be interested in learning more about what's been happening with Germany's Federal Constitutional Court. Germany's Federal Constitutional Court is one of the most influential constitutional courts worldwide and a pillar of Germany's post-war governance. The court has been in the news more than usual in the last year or so, and perhaps more than the court would care to be, both in connection with constitutional reforms aimed at, and our panelists can tell me if they think this is a fair characterization, blunting the possibility that the right-wing populist Alternative für Deutschland, AfD party, could either exercise control over the composition of the court or block efforts to replenish the court when justices retire. There was also a bruising confirmation fight over the summer, which was without precedent in recent German history. To help us understand both these events, but more generally, the place of the Constitutional Court in the past, today, and in the future of governance in Germany, we have two very distinguished panelists to whom I'll turn things over almost immediately. We have Joshua Spannaus, who is a research assistant at the Justus-Liebig-Universität in Giessen. He's doing doctoral work relating to constitutional rights and is also practicing at a law firm focusing on public law issues in Bonn. And we also have Russell Miller, who is the J.B. Stombock Professor at Washington and Lee University in the United States. Russ Miller has worked on the Constitutional Court as a clerk. He has written extensively about it. In fact, in the last year or so, written two different books relating to German law, one focused on the decisions of the constitutional courts and the places important to constitutional law in Germany. Joshua Spannaus will start us off with some overview of his perspective of the court's place in German law and politics. And then Russ Miller will take it from there, providing his commentary on these events. And then we will turn it over for a discussion to address the questions, comments, provocations that the attendees have brought to the table. So without further ado, I pass the mic to Joshua Spannaus.
Yeah, thank you so much, Judd, for that warm introduction. And I really feel honored to having the opportunity speaking here today about our beloved German Federal Constitutional Court, which we will call in short form GFCC. So let's get started immediately. I think across the world, constitutional courts are exposed to attempts to capture and destabilization by radical forces. Insofar, Germany has been no exception. So at the end of last year, the German constitutional legislature decided to make the institution of the GFCC more resilient to obstruction by means of a constitutional amendment. For us, this should be reason enough to reflect on the foundational principles of the GFCC. I will attempt to make the GFCC more vivid by highlighting 7 of course, multiple other characteristics I find the most interesting about the GFCC. And the first one is that the GFCC is a form of concentrated, specialized constitutional jurisdiction. This means that in the German legal system, the GFCC has a monopoly on the final authority to review the constitutionality of state actions. So only the GFCC has the power to declare statutes passed by the German Bundestag null and void on the grounds of a constitutional violation. However, its role is then limited to reviewing state actions for their compatibility with the basic law. So unlike the US Supreme Court, which is an integrated constitutional court and thus also the highest court in non-constitutional matters, the GFCC is restricted to constitutional review. Secondly, the GFCC is not only a court, but it's at the same time a constitutional body. In contrast to the Supreme Court on the federal basis, on the federal level, the GFCC is administered detached from the Federal Ministry of Justice. That's something that we shouldn't underestimate. Apart from that, it has its own rules of procedure. In general, the status as a constitutional body strengthens the independence and equality of the GFCC vis-à-vis the other constitutional bodies. Thirdly, I think beyond this Janus-faced role, the court has another dual structure. It is divided into 2 senates, each with 8 judges. The senates are in turn divided into chambers of 3 judges each. In fact, over 90% of constitutional court proceedings are decided in the chambers. This is because the chambers are called upon to decide especially about cases in which the legal standards have already been developed and sufficiently clarified. Only in more complex proceedings do the senates decide. With roughly 6,000 constitutional complaints that are filed each year, it is practically indispensable that as a rule, the chambers that can decide more rapidly are responsible for the decisions. Despite being structured into senates and chambers, rulings are always issued on behalf of the GFCC as a whole. Fourthly, we have a pretty peculiar style of reasoning that we can perceive when looking at the GFCC. The peculiar advisory culture guarantees that cases are decided on the highest legal level. The style of reasoning rather resembles a scholarly treatise. References to constitutional law scholarship are abundant, and also the large number of self-references is striking. An essential part of GFCC's culture of reasoning, furthermore, is that decisions are based on previous case law. This is at least a de facto commitment to precedent, and it is also an important mechanism of judicial self-restraint. Another self-restraint factor that should not be overlooked is that the judges' deliberations take place in a setting that is characterized by confidentiality. So there we have to rely on what former judges tell us, but according to their reports, this is a decisive condition for the success of GFCC's work. Since judges are only elected for a limited term of 12 years without the possibility of re-election, they have almost no interest in judging cases not primarily based on the best constitutional argument that prevails. Anyone who breaks this unwritten consensus, that we should only focus on constitutional arguments and weighing them against each other, and anyone who enters the realm of political polemics has put themselves on the sidelines and will be quarantined by the other judges in the specific case. This judicial work ethic would be merely theoretical if a certain political balance among judges were not ensured. Therefore, half of the judges is elected by the Bundestag and the other half is elected by the Bundesrat. In both cases, a judge must obtain a 2/3 majority. Owing to the fact that until now no single party or coalition of governing parties has yet achieved this 2/3 majority alone, the selection of federal constitutional judges is still a political compromise. Even though judges do not have to be completely apolitical, candidates will only prevail if they are at least acceptable to part of the opposition across party lines. As a result, we usually witness a tendency towards politically moderate judges. Fifthly, the subject matter on which the GFCC has to rule, that is the Constitution, addresses primarily political decision-making bodies. Moreover, constitutional norms are particularly vague and indefinite, and therefore they are susceptible to assessments. Both factors might lead to getting engaged in political value judgments. Nonetheless, it is the high degree of dogmatization of constitutional law which, from my perspective, counterbalances this risk. In collaboration with constitutional law scholarship, the GFCC has from time to time distilled so-called standards, that is to say, semi-concrete interpretations of the Constitution's texts that are on the one hand intended to resolve concrete conflicts in specific cases, but which at the same time extend far beyond the unique setting of a case and which take on significance beyond the concrete case. Sixth, interestingly enough, the legal dogmatic power of the GFCC is out of balance with its ability to enforce its decisions in practice. The court does not have any independent means of enforcement at its disposal. Rather, it can only hope for the cooperation of other state organs that are being controlled by the GFCC. Seventh and last, all these characteristics of the GFCC promote substantive, well-considered court decisions. But we have to admit that the mentioned features do not ultimately guarantee that constitutional law can be continually updated to meet the requirements of the present in the face of new and often unforeseen developments. The fact that constitutional law continues to be an integral part of everyday life, not only for legal participants, has a lot to do with the self-image of the court and its judges who consider themselves as being like the persons in charge of enhancing constitutional law. Last year's December, the majority of the democratic parties therefore eventually noticed all, and I have to stress that really all of the characteristics of the GFCC had been considered worth maintaining. The open flank from a legal perspective, though, was that many of the characteristics that I outlined could not be directly derived from the Constitution's text. Until then, the regulations on the term of office, of judges, the number, their re-electability, and the maximum age limit, or furthermore, the division into two senates, or the autonomy of the rules of procedure, as well as the status as a constitutional organ, had been contained exclusively in a federal statute. The problem was that this could be changed quite easily at any time by a simple majority in the Bundestag. So through the latest reforms, the regulations with reference to status, organization, and binding effect of rulings have been elevated to constitutional law, with the result that from now on, those new regulations can only be changed by a 2/3 majority in both the Bundestag and the Bundesrat simultaneously. However, this does not simply settle the resilience debate. Crucial issues are still not beyond the reach of the simple majority in the Bundestag. For example, the amendment has not elevated the requirement of a 2/3 majority quorum for the selection of judges of the GFCC onto the constitutional level. Those legal implementations of reforms could be hotly debated in detail. I want to, however, limit myself to the following concluding remarks. Any amendment to the text of the Constitution should be carefully considered. Often, constitutional reforms must be viewed ambivalently. On the one hand, the present constitutionalization can be justified insofar as it makes attacks on constitutional law and on the GFCC more difficult. On the other hand, the rigidity of constitutional amendment also has a downside. It can at times deprive democratic majorities of their flexibility, which they occasionally need. Is this like squaring the circle? Probably. We should bear all of this in mind when discussing the GFCC. Many thanks for your attention.
Russell.
Joshua, thanks so much for that really concise and informed treatment survey of this remarkable institution. I'd like to just begin my remarks by saying how grateful I am to the Humboldt Foundation for its recognition and support of my work over the years. And I'm really pleased to say that the fellowship I received some years ago helped me complete one of the projects that Jud mentioned at the top of this seminar. So I'm really pleased to be able to join the Humboldt community again. And I'm really happy to reflect with Joshua and Jud and others on the meaning and impact of this federal constitutional court. I will second and join Joshua in calling it also my beloved federal constitutional court. I'm very fond of this remarkable institution, but I want to say I'm fond of it both because of a sense of deep loyalty and affection I have for the institution, but also because it produces so much remarkable and dynamic jurisprudence and constitutional structural points of discussion. It is a lively and alive institution that merits our returning to it in a very critical way as well. So I'm fond of it for its dynamism as an object of scholarly interest. I will remark that it's nice that we've gathered this way to talk about the court, and that Joshua has given it this glowing portrayal, because of course it will turn 75 next year, and any institution that is 75 years old probably merits a little bit of affection and a warm portrayal. I'm very pleased, however, that Joshua ended his remarks by highlighting, even though the general portrayal of the court was I would say the traditional mythological depiction of the institution, that he didn't neglect at the end of his remarks the possibility, the very idea that it operates as any apex institution that engages in judicial review, does, it operates in a tension with the democratic ideal. And, this is actually a self-evident part of constitutionality and constitutional life that somehow Americans are more sensitive to. We have the benefit of deep scholarship around the counter-majoritarian character of judicial review, and we have large, deep political sensitivity to the risks of judicial activism. And maybe you see already that the degree to which Joshua only makes vague reference to those inherent tensions in constitutional review with respect to the Constitutional Court, that those critical elements of the life of the Constitutional Court aren't quite as present in Germany. It's remarkable that that's true. It's remarkable that it's given the benefit of this largely apolitical portrayal and understanding, despite the fact that all political actors in Germany understand that all of their policy decisions must eventually, as a political matter, must eventually be addressed by and resolved in Karlsruhe at the Constitutional Court. It's remarkable that part of ordinary German political discourse is the phrase, "Yeah, but I'll see you in Karlsruhe." That is, even after a policy debate has been resolved on majoritarian terms in the parliament or in the government, everyone understands that politics actually find their resolution at the end of the day at this institution. And maybe we're starting to see in the amendment process, the recent amendment process that Joshua described, but also in the appointments crisis that Judd described at the top of this seminar, maybe we're beginning to see the gradual emergence of greater awareness of the political position, the political meaning of this court. And so maybe I could say just a little bit about that appointments crisis from this summer. But again, I'm mentioning it as a way of drawing a bit of a contrast to the fair, very traditional portrayal that Joshua has given of a largely apolitical institution. Now we're seeing that its longstanding political resonance is beginning to spin off political meaning for the institution itself. So, alongside the amendments that Joshua described, some evidence of this new sort of political understanding of the court, or political posture of the court, emerges from the failed appointment of 3 new justices to the court over the summer. Joshua didn't describe this, but appointments of the court's 16 justices are divided between the 2 political bodies. The Bundestag, the federal parliament, elects 8 of the court's 16 justices, and the Federal Council of States, the Bundesrat, appoints the other 8 justices. And they do so in a political process with a political vote. Traditionally, and he did make reference to this, a committee of the Bundestag was responsible for electing the Bundestag's 8 justices by a 2/3 majority. But that appointment process, located exclusively in a committee, was changed by an earlier constitutional reform from 2015, a reform that made the election of the Bundestag's 8 justices a matter for the full plenum of the Bundestag. So it moved outside of the more controlled, less politically present or politically transparent possibility of a debate on the floor of the parliament. It moved it away from the committee into a full plenary vote in 2015. And then the Bundesrat elects, also by a 2/3 majority, its 8 justices. The other element of the politicization or the new political profile of the court must be evident in the long-standing reality that the process for identifying which parties will name appointees to the court for a vote either in the Bundestag or in the Bundesrat. This process of the rotation of the parties' opportunities to identify a candidate for election to the court is conducted largely on informal terms by tradition. That isn't statutorily ordained, let alone constitutionally ordained. And that means that the main political parties have had the opportunity to informally horse trade a little bit the order in which those vacant positions are filled by the political parties. So you can see that despite the truth of Joshua's portrayal of this institution as largely apolitical, dedicated to ruling on these highly politicized matters through dogmatic terms, nevertheless operates against a backdrop of political understanding of the court, a political role for the court, and some politicized qualities to the way the court's justices are selected, now by the full plenum in open debate at the court, and in straightforward partisan informal arrangements for the naming of the positions. It's against that backdrop that the 3 named appointees over the summer for 3 vacancies met with some controversy, particularly the one of the 2 SPD identified candidates for a new appointment, Professor Frauke Brosius-Gersdorf, met with some surprising controversy after having been cleared by a 2/3 vote of the Judicial Selection Committee in the Bundestag. She met resistance to her appointment in the full plenum of the Bundestag. That is, she had the clear understanding, and the parties had the clear understanding that a 2/3 test for her candidacy had already been cleared, and it should have just been a matter of party discipline that would have led to a similar 2/3 approval of her candidacy in the plenum of the Bundestag. But in fact, there was a defection within the center-right parties, the union parties, around her possible nomination. And what generated that, it's still a bit of a mystery, what led to that intense politicization around her nomination this summer. There were some ideological objections around her published positions as a scholar on abortion jurisprudence, and some objections to her published commentary or public commentary on vaccine mandates during the COVID era. Those might have been ideological bases for opposition. There were totally unsubstantiated, ultimately proven false allegations of plagiarism as well. So there was some personal or ad hominem elements of this opposition. But this defection by a handful of union members of the full plenum of the Bundestag would have deprived Brosius-Gersdorf of the necessary 2/3 majority. And that led the chancellor to simply suspend the vote over the nomination and empanelment of these 3 justices over the summer. All right. I've told this story largely as a way of adding some dimension and a constructive reflection on the truth of the court's political profile, the political meaning of its work, and increasingly the political nature of the appointment of justices. Again, as a way of simply adding some texture to Joshua's portrayal, which is sound and I largely share.
Terrific. Thank you so much, Russ. So I know we'd like to make this a discussion in the spirit of Humboldt Dialogue. So Janka, the way that happens, right, is people enter questions into the Q&A. Is that correct?
That's correct. Yes.
Okay. Are there some already?
Checking now. Not
And
yet.
while Janka's checking, maybe Joshua, just a moment for any reactions you have or comments on the Brosius-Gersdorf situation.
So first of all, as you, Russell Miller, have emphasized, is the movement towards a politicization when it comes to the plenum being in charge of decisions about the election of candidates for the Federal Constitutional Court. But maybe I can insist there that from my perspective, the plenum does only vote secretly, and there is no possibility of like negotiating or something like this about the candidates which have been chosen at like before from the committee that has to give like their approval with a also 2/3 majority. So I mean, it might be a factor, it might be of symbolic impact, but I think due to the fact that the plenum doesn't have the power to decide like in terms of on the subjects of on the personality of the judge itself, this is something I think we should consider too.
Yeah, it's a great insight. You're right. It's not anything like a move towards the circus of the appointments process that we're familiar with in the American tradition. So you're right. But it's worth asking or reflecting on, why it might have been necessary. What if it's such a restrained, and again, in essence, maybe you're making the argument, still a rather apolitical process, this full plenary vote. It's worth asking why it was necessary to make that reform. The reform of moving the appointments process from a relatively obscure and not perfectly transparent committee to the full plenum, a vote of the full plenum, must have been meant to achieve something. And I understood that amendment and that reform to be a recognition of the court's political meaning in the life of German politics, and to try to reinforce its standing by lending it some legitimacy. I mean, the problem with the counter-majoritarian problem of these apex courts is that they're ruling on these political matters, but lack the direct political accountability, and there can be a legitimacy deficit there. And so I'm not sure you can have it both ways. You can't say we needed that reform in order to endow the court with some political legitimacy because we recognize that it's doing political work, and at the same time say, but it's really just some smoke and mirrors. It wasn't meant to actually overly politicize the process. I mean, one reason we had the crisis this summer is because of that reform. Had it just been kept in the Judicial Selection Committee, where her nomination received the full 2/3 approval, then this wouldn't have unfolded the way it did. And so it's worth reflecting, why was it necessary to have this reform? And if part of the justification for that was to help resolve the inherent counter-majoritarian difficulty of these apex courts ruling on popular democratic policy, then I think we should accept that that's also a slight politicization of the institution. That was the intention.
So we have a question from Denny Bagmeyer. There has been much written recently about difficulty in amending the US Constitution and thereby allowing de facto amendments left to sitting justices. What is the history of amendments generally in Germany, number proposed and number adopted?
I don't know if you want to answer, Russell, or
Yeah, as a American trained scholar, I feel highly unqualified to even talk about constitutional amendments. In some sense, I'm obliged to respond, what is this thing you speak of when you say constitutional amendments? But of course, the process for amending the Constitution in Germany, there is this notion of an amending majority of the government or of the parliamentary process in Germany, and that is a two-thirds majority. It's possible to amend the Constitution with a two-thirds majority of the parliament. And in light of that possibility, when there are grand coalitions in the old days of German politics, when it was possible to assemble a two-thirds majority through a grand coalition of the two centrist parties in Germany, the Union parties and the Social Democrats, those two parties occupied enough space in the political middle that a grand coalition of those two parties would generate a constitutionally amending majority. And because of that, we've seen over 60 amendments in the 75 years of constitutional life of the basic law. And so I would say that it's in the view of a comparativist from the US, it seems like a sort of healthy, living, flexible potential. That is, it's at a pretty robust pace, but it still has to be a serious majoritarian expectation around amending the Constitution in Germany. It'd be interesting if we could reflect on what some of those amendments looked like. I mean, the major Big Bang constitutional amending moment came with the security measures in '68 and the possibility of pursuing some greater security surveillance in Germany. In the early 2000s, a grand coalition was able to pursue federalism reform on the basis of some constitutional amendments. I'd say as a last matter, it's worth noting, again, to underscore the underlying political character of everything we're talking about, even though it is a respected court that does respectable work on law, is that the amendments Joshua described to the Constitution, the amendments of the last year that were aimed at reinforcing the integrity of the court, were achieved by a lame duck supermajority of the parliament. And that is a really remarkable achievement, and is worth really reflecting on, is a majority that is clearly headed to an election where it's expected that it will be revised and maybe unseated. Is that a legitimate supermajority that can rush through constitutional amendments before an expected snap election? That sounds like constitutional amending work, but it's also a quite politicized maneuver to secure changes to the Constitution before an election that will produce a completely new constellation of a majority. That's politically dramatic.
And if I can just add to that, it's also notable that the effect of these amendments was to take out of the scope of regular democratic politics decisions and enshrine them in the Constitution. So it's a body with waning democratic legitimacy at the end of its term, taking away a decision that would be left to the democratic organ of government. That's not to say it was the wrong thing to do, but I think it's a difficult question as an American looking across the ocean at the Constitutional Court and kind of valuing it. and wanting it to be resilient against challenges, um, but also recognizing the very real challenges posed by political landscape that's becoming perhaps rougher. Certainly, the U.S. political landscape has kind of the consensus politics that have been possible in Germany in the past seem less possible going forward. How do you preserve an institution against a changing political climate without further exacerbating the tension between its exercise of power and the baseline expectation that in a democratic polity, important decisions are made democratically?
Yeah, Joshua, I'd love to hear, your reflections on this from inside Germany. I don't know whether this point that I've raised about the sort of the lame duck amendment of the Constitution, literally, to avoid a new majority, an imminent and inevitable new majority's action around these issues. Whether there was much debate around that dimension of those developments, what that debate sounded like, if there was absolute and widespread consensus, categorical consensus around the necessity of that maneuver. I'd be curious just to how you reflect on that, and whether you can reflect on debates around that point.
So I can just only say how I perceived it, and interestingly is that the lame duck problem occurred, but we sort of were relieved that finally they made like the reforms. They could take like they could be like enforced, or they could they could be like valid. Another thing that was like debated is that some of the reforms, at least, were until then already considered to be constitutional law, even though unwritten. So, of course, we do have like the concept of not, or the prohibition of changing constitutional law without changing simultaneously the text of the Constitution itself. But like that comes to a sort of a paradox if we take into account that, of course, there is lots of constitutional law existing that is unwritten. So, like considering the binding effect of rulings of the GFCC, if we hadn't a new regulation in the Constitution, like we wouldn't lack, or we wouldn't kind of how to say it, Judge, vermissen.
You wouldn't have been
Wouldn't have been
lacking.
missed. Yeah.
Yeah, you wouldn't have missed this. But this is
exactly.
a formalization of existing jurisprudence and practice.
Yeah, exactly. So, like, there's a sort of mistrust that in the future the GFCC will issue the same rulings it has done in former times. So, like, we can only secure that this keeps on if we change the Constitution itself. So there's another like level of the constitutional amendment that has not to do with the subject, the matter, but like making it more resilient just because it is text. Yeah.
Yeah, I love that you've highlighted this, Joshua. One of the things that I find so rich and interesting about the institution is that as a constitutional court, it necessarily operates in the nature of constitutional law work that is something that is in its character closer to the common law than the old continental positivistic law. But what you've just described is that wasn't adequate for the German legal soul. The political soul actually needed that old civil law, continental positivistic text to be reassured, even if it wasn't formally necessary, that they had plenty of case law that would have achieved the same result. I don't know where that takes us in this debate, but I love that you've highlighted this sort of dual character of this particular institution. Of course, we could say something similar about the U.S. Supreme Court. It lives and thrives on its precedent, but a number of the justices now are radically committed to understanding their work as exclusively the project of interpreting positive text, that is, the text of the Constitution, and are openly saying we're not interested in case law anymore. We're only interested in the correct interpretation of the text of the Constitution. So we see this, dual character, this struggle in the soul of these courts, maybe on both sides of the Atlantic. But I'm glad that you've highlighted that case law in a case law centered institution wasn't even enough. You still needed to satisfy the German soul. You still needed that old continental positive law change.
Yeah, guys, see there's a question in the...
There's a comment from Kevin Kenny. I think this goes back to amendments 60 plus in Germany in 75 years compared to 27 in the US in about 238 years. Presumably, it is actually a good thing to have a stable constitution.
Yeah, I mean, I think the discussion we just had highlights really how dynamic the question is. How often has the Constitution been amended is a strictly formal question to which we can give numbers, 27 or 60 plus. But as Joshua was saying, the reality of constitutional practice is also found in the opinions of the court, the definitive interpretations of the Constitution. So, one answer would have to be that the U.S. has a couple dozen constitutional amendments and, more than 300 volumes of the reporters of the Supreme Court opinions, and that's the full text of the Constitution. So there's a couple of ways to measure stability and flexibility, and that would be to sort of cross-reference formal amendments, which as we know don't always actually generate tangible constitutional change. The 14th Amendment's demand for equality sat unrealized for 100 years in the United States, even though the text was clearly there. The jurisprudential and political will to realize that promise didn't exist. So we would have to cross-reference textual change with jurisprudence from the court and maybe even the political will, constitutional political will, to really know the truth about the stability and dynamism of these constitutional traditions.
If we were building a sort of Frankenstein monsters constitutional court from scratch and could borrow elements, I would gladly take Germany or on other places comparative ease of constitutional amendment. So the short answer to why there have been so few constitutional amendments in the United States is that it's so hard to amend the Constitution, requiring not just supermajorities in Congress, but also in the states. I think it's a healthy, from an American's perspective, enviable proposition that the Constitution can be meaningfully and substantively changed in response to new issues that come up. Also because that takes some of the pressure off the court to somehow find a way within a text that may not be congenial to that outcome to adapt to these problems. This is an issue that the U.S. Supreme Court must face, that a court in a system like Germany's, where amendments possible and frequent, may not need to face with that kind of frequency. There are all kinds of ways in which constitutional courts are exposed as lawmakers of a sort. And if I were on a constitutional court, I'd welcome any institutional changes that would reduce the times. I would feel compelled to kind of leap into the breach to make a ruling that is hard to square with the text of the Constitution. So that's a feature I'd gladly take on board.
And I'd endorse any court that would have Jud Mathews as a justice. So I can agree with that.
If we can turn for a moment to the nomination process. So again, I didn't follow it closely, but it did sound like, as Russ mentioned, as part of the controversy about the Brosius-Gersdorf nomination, there were some low blows, including unfounded allegations of plagiarism. As someone who is also a great fan of Germany, its legal system, its constitution, and its constitutional court, I wouldn't wish the U.S. nomination process on Germany or my worst enemy. But I think to Russell's point, it does raise a question: what should the public or the public representing body, the legislature's role be in a substantive engagement with the views of potential justices on issues that are likely to come before them? So this is something that, again, is on display in the United States in our confirmation hearings. There's maybe more heat than light in these hearings, but it is a chance for the people's representatives to ask these folks, who in our case will have life tenure, what do you think about these questions you're likely to be faced with? Joshua, I'd be interested in your views about to whether and to what extent that kind of engagement about these issues would be appropriate.
So generally spoken, I think we shouldn't pretend to say like that judges are really apolitical, in the sense maybe my image of the GFCC has emerged, but I think the whole thing about Brosius-Gersdorf showed that at least there is sort of the possibility that it indeed was a campaign, because the plagiarism and so on, it came to the discussion the same day she should have been elected by the Bundestag. Apart from that, I don't think that it's a bad thing to shed light on the background of a person, and so we always select persons that have a background and that have made investigations on different subjects. And especially Brosius-Gersdorf did make research on and sophisticated research on abortion, and also the obligation of being vaccinated during the corona pandemic. But what we sort of conflate is that these are scholarly, these are actions he did as a scholar, and so what we should practice more is that we should, in the public debate, we should make clear that constitutional law always has this link to political measures, but that anyways we can discuss constitutional law also on a legal basis. So that's what Frauke Brosius-Gersdorf did, and especially when it comes to human dignity, when you state that human dignity might have to be interpreted differently from what it used to be interpreted like in former times, then that's not a decision she'd made. Then it's just giving input into the context of the research. So I think it's an issue of how you how you communicate your personal background.
Yeah, and I wonder, Joshua, as you described that, I wonder if somehow the perpetuating the myth of this strictly dogmatic scientific work of the court is sustainable against the reality of its political backdrop and the political processes that justify it. And so I think part of what you're saying is maybe not so much a formal revision of the processes, but not just a new understanding of the work of scholarship, but a new understanding of the work of political constitutional jurisprudence. It's sort of a grown up, maybe at 75 years old, we can begin to treat this institution as a grown up, mature institution. We don't have to keep enshrouding it in these myths of science, scientific dogmatic work, or strictly apolitical work, especially when that will be, it's evident that that's not always going to be true, that it will sometimes be acting in quite profoundly political ways, whether that's a sustainable myth. And maybe at 75, it's time to begin to allow it to behave as an adult and to treat it as an adult. That would be an interesting thesis. I will note that, you mentioned that it was the question of human dignity that became, her possible reading of human dignity that became one of the flashpoints in the controversy. And, she is a student of Horst Dreyer, who is a, beloved foundational scholar of the German Constitution, who himself was a nominee or considered as a possible candidate for a nomination to the Constitutional Court in the early 2000s. And it was his own scholarship around the possible meaning of human dignity that led to something not quite the same open controversy that we saw this summer, but to eventually hit the withdrawal of his possible candidacy. Of course, that all unfolded prior to the reform that made this a decision of the full plenum of the Bundestag. That happened in the Judicial Selection Committee, and so it gathered something like less sensational media treatment. It was much more a matter for those involved in or interested in the work of the court that would have been aware of that. So those are sort of two test cases with a strong relationship, both around doctrine, the question of human dignity, and a legacy of scholarship between her work as one of his students.
I think we're at time, so I'll turn it over to Janka to conclude.
Great. Thanks everybody for joining us. This event was recorded and will be available on our website in the next few days. And please stay tuned and check our website for upcoming dialogues. Thank you, Judd, for moderating this great event. Thank you, Russell and Joshua, for participating and sharing your perspectives on a really interesting topic. I think we all learned a lot. Thanks, everybody.